What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. I've got three good ones. I've got three pro se cases all in front of Judge Clarke, all on the same docket. They were pretty much back to back to back. So just put them all together for you guys. I hope you enjoy it. These aren't so much pro se shutdowns. They're just kind of entertaining to watch pro ses, just struggle with basic English, I guess. I don't know how else to say it. They just struggle. They always do. They don't know the court procedure, and you can tell. But let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Now let's go.
Davin Bowden. I'm sorry, Honor. I thought he was in the box.
Right here.
You are? Okay. I know, that's why I was calling your name, so you could come forward, Mr. Bowden. Your Honor, Mr. Bowden is representing himself in case 252223.
You must have been appointed public defender at first appearance.
No, I made sure that I made it clear on the paperwork when I got arrested and they brought me into the jail.
I'm just saying what I say. Hold on, Mr. Bandit.
Yeah, I never got to send the paperwork back to them. They sent it to me.
Yeah, it looks like he was appointed public defender. Is that correct?
No, shouldn't be.
I'm not talking to you, Mr. Bandit. I'm talking to the clerk. Madam Clerk.
On the indigent form, he put first, and then part not indigent at the bottom. I don't see.
Hold on, maybe I'm looking at the, what's his name? Jason?
Devin Bowden.
Bowden.
Oh, Bowden.
Israel. Yeah,
I got it. I was at the wrong one. All right, Mr. Bowden, you've indicated that you do not wish to be represented by counsel. Is that correct?
Yes, sir.
All right, you're charged with one count of grand theft. That's a third-degree felony, punished with 5 years in the Florida Department of Corrections and a $5,000 fine. I am going to take some testimony from you to see if you're competent to represent yourself, okay?
Sir?
I'm going to take some testimony from you to see if you're competent to represent yourself. If you'll raise your right hand to be sworn.
I don't raise my right hand, but I'll firmly tell the truth. That's my religious practice. I'm Hebrew. First Amendment.
All right. So you've indicated you want to represent yourself. Is that correct?
Definitely do.
Okay. How far did you get in school?
No matter how far I got, Judge, trust me, I can do
Mr.
this.
Bandit, Mr. Bowden, you're not going to represent yourself unless you answer these questions for me,
The
okay?
11th grade.
Sir?
I've been to the 11th grade.
Okay. You can read and write.
Yeah, I can read them, right?
Okay. And what do you do for a living?
I work.
Okay. What kind of work do you do?
I work with High Quest right now, and I got my own little business thing that I got going on.
Okay. What kind of business?
I do pressure washing, I do lawn service.
All right. And have you ever represented yourself before?
Hey, Judge, I got a history for Washington County, Okaloosa County, Brevard County, and this county.
Okay. And are you under the influence of any drugs or alcohol this morning, which will impair your ability? Just wait, let me ask the question. If you've done it before, you know I've got to ask these questions before you're allowed to do it. Okay. You have a right to do it, but I have to make sure. So, are you under the influence of any drugs or alcohol this morning, which would impair your ability to make this decision?
No, sir.
All right. Have you ever been diagnosed with a mental illness that would impair your ability?
No, sir. I've had 2 evaluations by Okaloosa County and Brevard County. If you want to get an evaluation for that goal, we can do that too to show you that.
Yeah, I'm just asking. I'm just asking on your testimony today.
Right. But no, I'm very competent.
Okay. All right. And you've represented yourself before. I'm gonna find that Mr. Bowden's competent to represent himself. Madam Clerk, if you'll print out a copy of the information, and then Mr. Bowden, if you'll once you get that, I'm gonna ask you to enter a plea. Okay,
sir.
I'm gonna ask that you observe to review the information the state's filed against you, and enter a plea at that time.
Or not guilty.
Okay. Well, let's wait until they get go ahead and see. Mr. Bowden is receiving the information, and you've entered a not guilty plea. Is that correct, sir?
Oh yeah.
Okay. And we'll need to set a pretrial. Let's set it for September 18th at 9 o'clock.
Also, Judge, with this county jail I'm in, Bay County, I don't know what they got going on over there, but they said the prosecutor said not to give me indigent legal supplies so I can prepare my stuff. I had an attempted murder made on my life. I have a titanium rod in my neck. There's all kind of crazy stuff going on over there. But yeah, they said the prosecutor officer said don't provide me with a indigent supplies to do my legal stuff. they know I'm a writ writer, so, you know, I mean, pretty sure all the stuff I write, I can write to the Attorney General's office and, you know, let them know what's going on.
Well, I don't know what I can do about it, but, as far as what I'll do is I'll, ask the Bay County Jail to give you access to whatever, they have, for you to represent yourself.
Right, that's the first, the fifth, fourth, and sixth, eighth, and 14th Amendment. They supposed to do that.
Yeah.
And they got a habit or not, but like I said, there's a lot of corrupt stuff going on, and you know they try to avoid that and feel like they can do what they want to do. And like
What amendments did he just say? I didn't keep track. He I think he said all of them. He didn't say all of them. He listed off 5 or 6 though. I need to go back and check what numbers he said just so I could check what amendment he's citing. Because I swear he just said the 3rd Amendment. Like 3rd, 4th, 6th, 8th, 12th, 14th. I don't know.
my Constitution don't stand for something, so you know I'm just making this part of the appeal record that I'm starting with this.
Okay.
You know.
All
So,
right.
you know, I appreciate if you'll make sure I got everything that.
Well, all I can do is ask them. I can't, but I'm gonna ask them and you put it part of the record.
Yeah. I mean, you know.
Okay?
Yes, sir.
All right. That'll conclude the hearing.
All right.
That's not his paperwork.
Yeah.
Good morning, Mr. Edwards. You're before the court today for your arraignment. You've been charged by way of an information with burglary with assault or battery. That's a first-degree felony. It's punishable to 30 years in prison. Mr. Edwards, you indicated at first appearance you did not wish to be represented by an attorney. Is that correct?
Sure.
All right. Are you going to hire an attorney or do you wish to represent yourself?
Sure.
Okay. If you'll raise your right hand to be sworn.
This testimony you're about to give is the truth, but the truth.
Yeah, state attorney. I need to talk to state attorney.
Pardon?
Do you get state attorney I can talk to?
Well, I'm gonna ask you some questions about representing yourself to start with, okay?
Yes, sir.
All right, Mr. Edwards, you're charged with, by way of an information with a first-degree felony, burglary with assault or battery, and it's punishable to 30 years in the Florida Department of Corrections. How far did you get in school?
10.
Okay. Can you read and write? Yes or no?
Did I ever read?
Can you read and write?
Yes, sir.
Okay. And are you employed?
Mm-hmm.
What do you do for a living?
Cut trees.
Okay. And have you ever represented yourself before?
Yes, sir.
All right. In what courts?
This court.
Okay. In front of me?
Nope.
Or just a circuit?
Judge Van.
All right. That's in county court.
Sure.
Okay. Have you ever represented yourself in felony court?
First time.
First time. Okay. All right. And are you under the influence of any drugs or alcohol today, which would impair your ability to enter the agreement or understand the terms and conditions of it?
Yes, sir.
Have you ever been diagnosed with a mental illness that would prohibit you from making this decision
Yes, sir.
or impair your ability to make this
Yes,
decision?
sir.
Do you understand that attorneys are trained in the rules of evidence, criminal procedure, and the law? They're there to assist you in pretrial motions and preparing for trial. Do you understand that?
Yes, sir.
And you wish to waive all that and represent yourself?
Yes, sir.
Okay. I'm gonna find that Mr. Edwards is competent to represent himself. Madam Clerk, if you'll print out an information and give it to Mr. Edwards.
First.
All right, Mr. Edwards, you've received the information. Are you ready to enter a plea?
No, sir.
Pardon?
No, sir.
You're not ready to enter a plea?
No, sir.
When will you be ready?
I talk to the state attorney.
Okay. All right. I don't know if the state attorney is going to talk to you or not.
That's up to him.
Mr. Jackson?
I don't believe we've had making contact in this case yet, Your Honor, so the state doesn't have an offer at this time.
There's no offer. Do you wish to enter a plea?
No, sir.
Okay. Sir?
They offered me to police car.
I can't understand you.
They offered a police car. They offered me to police car.
Well, this is the time to enter a plea of guilty, not guilty, or no contest.
Right. To what?
You've been charged with burglary of a dwelling with a battery or assault.
Yeah, I'm trying to tell the state attorney though.
Okay. State attorney doesn't have time to talk to you this morning. What I'm gonna do is I'm gonna find that you're standing mute. I'm gonna enter and I'm gonna take that as a not guilty plea.
I go to the interview today.
Sir?
I'm not interview today.
I can't understand you.
I'm not interviewing today. I mean, he's not guilty.
You're not guilty.
Well, no contest. Not guilty.
You want to enter a not guilty plea?
Yes, sir.
Okay. I'm gonna accept your not guilty plea. I'm gonna set this for September 18th at 9 o'clock, okay?
Mm-hmm. Thank you.
Yes, sir.
Hey, sir.
Yes, sir.
Motion.
Sir,
Motion to submit a motion to the court.
you can file it with the clerk's office and make sure you got do you have a copy for the state?
Well, they'll get one, can't you?
Well, you're supposed to serve them with a copy of it.
Okay.
But what I'll do is if you want to file it right now, you can file it. And then I'll ask the clerk to make a copy for the state. But from now on, anything you file, you have to give a copy to the state, okay?
Yes, sir. Yes, sir. This is a bond reduction.
Okay. All right.
$50,000.
Is that a motion for bond reduction? All right, I'm gonna set you for this Friday then, okay?
This is coming Friday?
Yes, sir. I will set Mr. Edwards on the Friday docket for a motion for bond reduction.
And I got another one. One more. One more motion.
Okay. What is it?
Go to release from custody.
One motion for what?
Release from custody.
Oh, release from custody. I will hear that from Friday too. Okay? You can go ahead and file it. Yeah, just go ahead and give it to the clerk, Mr. White, and then Madam Clerk, if you don't mind.
Yes, sir.
All right, that'll conclude today's hearing. Anything else?
Yes, sir.
I will see you Friday, sir.
Yeah. So just set them on what? Set them
Well, no, what I've done is I'm gonna take you off the September 23rd docket, and I'm putting you on Friday's docket since you filed a motion for bond. Okay?
All right. Just to state the obvious, I don't really. I think I picked out 10 total words that he said. I don't know how Judge Clarke understood that. Props to him. I mean, he did ask him to repeat himself a few times, but not as many as I would have. All right, last one. Let's go.
All right, Mr. Wells, are you representing?
No, I'm not.
Okay.
I didn't realize that you called him up.
Okay. Mr. Wells, you're before the court today for your arraignment. You've been charged by way of an information with 3 counts: traveling to meet a minor to commit unlawful sexual conduct. That's a 2nd-degree felony, punishable to 15 years in the Florida Department of Correction, a $10,000 fine. Solicitation of a minor for sexual conduct, which is a 3rd-degree felony, punishable to 5 years in the Florida Department of Correction, a $5,000 fine. And unlawful use of a two-way communication device, which is a 3rd-degree felony, punishable to 5 years in the Florida Department of Corrections. You've indicated you did not want a public defender. Is that correct?
Yes, sir.
Okay. Are you planning on representing yourself or hiring an attorney?
I might hire an attorney.
Okay. You have an information file, so what I suggest, I enter a not guilty plea on your behalf today. Do you think you'll have an attorney by September 18th?
I will have to talk to my family. If not, I will represent myself. I enter a motion for release on my own reconnaissance with the fact of them not filing charges on my last court.
That's mute. That's mute now since they filed an information. That motion is mute.
On criminal procedure 3.134.
Yes, sir, I'm very aware of that, but that's a mute. If you don't have the hearing if the information is filed before the hearing, it's mute.
I filed the information the day of.
I understand that, but it's mute if you didn't have the hearing before that date. The state has up until the
Could
time.
you explain more to me about what
I can't explain it to you any more than I'm not here to explain it to you. I'm here to just tell you what it is. Now, if you want to be considered, if you want to represent yourself, is that what you're asking for today, or do you want to wait and see if you can hire an attorney?
I want to wait to see if I can hire an attorney. With the Bail Reform Act of 1984, that's what I read, and that's what I thought could get me out of this situation, at least release on my own reconnaissance.
You'd be wrong. Okay. And that's just, I mean, the rule says it, but the case law is pretty clear, and the law is pretty clear that if the information is filed prior to you coming to court, that
there's clear convincing evidence.
It's not clear and convincing, it's the law's clear. It's not a burden of proof. Clear and convincing is a burden of proof. I mean, I'll be honest with you, that's not the first time I've seen it, and that's just the law, okay? Well, I'll give you till September 18th. Of course, if you hire an attorney prior to that date, they'll file a notice of appearance, okay? That'll conclude
Can I ask for bond reduction as well? Because in my first appearance, they lied and said I shot up a school zone, and in all records, my name is spelled incorrectly on my
Yeah,
first
I'm going to
and
deny
middle
that
name.
this time until if you want to file a motion for that, or if you have an attorney, they can file that motion, okay? That'll conclude the hearing.
Yeah, short story. Long story short, you're not getting out of jail. You're not getting out. Good attempt though. You kind of got props from Judge Clarke. I mean, he told you you're wrong because they filed information before today, or before this hearing. Yeah, that those aren't charges you want to represent yourself on, man. Take a public defender. If you retain an attorney, they can swap out. But man, you don't want to be representing yourself on those. All right. Those are fun, right? 3 pro say. It's a good way to start your Tuesday. I hope you guys enjoyed the video. If you did, please hit that like button. That's it. That's all I got. Until next time. Bye.
Yes, sir.